I am going to go ahead and welcome our panelists. So, Steve Barnes. Steve is the chair of NC Realtors Forms Committee. He has served on forms for the committee for 6 years. We are happy to have you here today, Steve. Next, we have Amy Baker. Amy Baker is past chair. She's NC Realtors Forms Committee, and she has served on the Forms Committee for 5 years. Welcome, Amy. And we have John Waite, Martin and Guilford, PLLC, NC Realtors General Counsel. Now, I am going to say, I know everyone is going to have a lot of questions, and we're going to try to answer as many as we can. Our panel does have a PowerPoint presentation that will address many of these questions, and we will be dropping helpful links in the chat during the event. If you have a question, can you type it in the Q&A box and we will get to as many as we can. Also, note this presentation is being recorded and you will be able to find it at canopyrealtors.com. Okay, let's get started. Welcome, panel, and thank you for being here.
Hello, everyone. I'm going to do a little intro for you here. Let me get my slides up. Let's see. Share. All right. That's showing on the screen now. Great. Steve gave me the thumbs up. Awesome. Thanks for everybody for coming. We're going to try to get through as much as we possibly can in our update today, and also get to a lot of your questions. First, I'm Amy Baker. I just finished my my year as chair. Now I have handed things over to Steve. So anything that changes in the forums next year, that's Steve's fault. Just message me, I'll get you his email. We also have the NC Realtors Legal Hotline pointed out at the bottom of this slide. That's a great resource for you if you ever have a question about a transaction. John is actually one of the attorneys that helps staff that line. So you may even get to chat with him if you call in. First helpful link, definitely check out the Realtor Q&A. John writes a good many of those and does a great job. Often in the Forms Committee meetings, we will say, hey, John, we think we need a Q&A on whatever. And then John whips it up and then post it there. So there's past ones you can search in the library. It's a really, really great resource. This is what that library looks like. As you can see, you can search based on keywords, due diligence, earnest money, whatever. Another helpful link, John has done a really great job on the NC Realtors YouTube channel, doing update videos each summer when we do the updates. Last year, he did quite a few. Oh, I put it out of order. I'll go back. This is what it looks like. So these are the 2024 videos. I don't think, if maybe John's posted one or two of the 2025s, but you'll see definitely more coming out there. So check that YouTube channel. You can see he did videos on individual forms last time. All right, now let me go back. Quickly, I've got some resources here. If you want to do, take a picture, right, use your camera app. We've got a link to the Realtor Q&A, that YouTube channel, and probably the one you might want to pull up for this is the summary of the residential forms changes. That's what we're going to be going through today. I'll give everybody a second to look at that. And we'll have these QR codes at the end of the presentation too. So if you miss them now, don't worry, you're going to see them again. I also have in here the auction forms, property management forms, and commercial forms, but not something we're going to address today. All right, before we begin, it occurs to me that some people don't really understand what the Forms Committee does, who we are, how do we do what we do. So I want to give a brief intro on the committee. Committee's made up of roughly 25 members. That does include legal counsel from NCREC. So we've got a commission representative in the room to make sure that everything that we do is in compliance with their rules. Members are selected through an application process on the NC Realtors website. Typically, those selections are made by the president of NC Realtors in conjunction and conversation with the National Association, not the national, oh my gosh, with the state association staff, right? Because they know us and interact with us on the committee. Typically, the goal is to be about 80% veteran members and about 20% new. We love to have veteran members because we see the same sorts of questions and requests come up a lot of times. And if we've already debated and say voted no change on something, we don't want to bring that up and spend committee time on that again. If we just talked about it last year, we've got some great members on the committee who can tell us stories about what was done 10 years ago in the committee. That history is very valuable. But we also want new members because we want that new take, that new perspective. Our appointments are 1 year. They run July 1st to June 30th. So we just rolled over to our new committee. We meet in person in Greensboro, sometimes virtually if the weather does not allow, or during COVID, we were virtual. But typically, once a month, all of these members of the committee are driving to Greensboro. We've got members from the mountains to the coast, so they are making a big time commitment. Typically, our meetings are 4 to 6 hours on the days that we meet. So again, big time commitment. In addition to our regular meetings, when we redo a big change on a form, later we're going to show you the net to seller spreadsheet. We will designate a subcommittee for that so that we don't have to hash out the individual details in the room at a committee meeting where we only have 4 to 6 hours. Members will volunteer to do additional time and meet on Zoom to do that. So they're adding to their volunteer time. We also have about 70 to 75 forms. So it's a lot. We are responsible for a lot. We certainly don't touch every form every year, but we do have quite a few to deal with. It's really important to know that there are some forms that we are not responsible for. The best examples are the residential property disclosure, the mineral oil and gas disclosure, and the working with real estate agents brochure. Those are not our forms. We do not have the ability to change those. Those are under the purview of NCREC. Also, about 20 to 25 of our 70 to 75 forms are jointly approved with the Bar Association. So there's a process we go through for these forms to be changed. For those 20 to 25, not only does the Forms Committee have to agree on the changes, we also have to take them to a joint forms task force where some of our members also serve, and attorneys on that committee weigh in and they have to approve them as well. Our staff liaison works with our chair to set our agenda for each meeting. So when you email in to us and ask about a change, the chair is who looks at that and decides what's going to go on to our agendas for each meeting. When we meet, we can edit existing forms, create new forms, or retire no longer used forms. We've done a little bit of all of that this year. Any changes that we make, potentially the Joint Forms Committee, also have to go to the NC Realtors Executive Committee. So you can see there's many levels. It's not just as easy as we decide on a change and it gets made. It's got to go through several levels to actually be approved. Our goal is to release new changes each July, but if there is something pressing, we do some off-cycle releases sometimes. You've seen us do that recently. Hopefully that tells you a little bit more about the committee, just so you sort of understand. We play a big role in your business, and we want you to know who we are, what we do, and how we get to be on the committee. All right, now let's get into it. John is going to start us off first by talking about the offer to purchase and contract and those changes. John, if you need me to go ahead a slide or go back, just say so, and I'll click around and get you where you need to go.
All right, thank you very much. And I'll take a moment to say thank you to everybody who volunteers on the Forms Committee. It takes a lot of time, effort, and energy. And yeah, no, it's very impressive to watch them work and make the forms work the best they can. So getting first into the offer to purchase and contract Form 2T, you can go to the next slide. This form got a pretty substantial update this year. The biggest thing you'll notice while you're going through it, if you're in the summary, if you clicked on that link, it looks like Courtney's putting links in the chat. If you want to look at that, you can actually click on those links and see what's actually on the screen, like in a full scroll form. And You won't see any of the note boxes or warning boxes anymore in Form 2T. Instead, that information has been simplified and moved into the contract itself, or it's been moved to the guidelines. So I can't remember if we're going to discuss the guidelines in any sort of detail today, but you can peruse those in detail, certainly at your leisure. So you can see at the top of the first page, not a huge change, except for you'll see a checkbox there for additional parcels. This is already in the auction contract, so it's just now moving it over into the regular residential contract. 2T got an update as well as 12T, the vacant land. So a lot of the stuff that we'll be discussing with the offer to purchase is also part of the vacant land contract, but we will not be discussing that form separately. So you got additional parcels in there. Otherwise, this looks substantially the same. If you go to the next slide, you can see that the second part of the first page is a lot different. And so now you've got seller concessions, due diligence period, and settlement date all on the first page. You might want to keep an eye on updates in the Realtor rundown over the next month or two. The General Assembly has passed a law that now agent commissions can be in a pre-printed offer to purchase. And that rule is effective now while the Real Estate Commission is developing and accepting input on their rules. So it's one of those things where, I'm not sure, what Forms Committee will decide to do with seller concessions, but I'm sure they'll be thinking about a couple different options. But right now, I mean, technically speaking, if you wanted to attach a custom addendum from your favorite closing attorney, something like that, to address agent commissions in the contract, you'd be able to do so now. The way the statute's written is that the rule's effective now pending the Real Estate Commission's final approval of its rules. So anyway, you might want to talk to somebody about that if you want to do it. Otherwise, if you want to keep using, Form 220 or use this seller concession that's on the first page, you could certainly keep doing that. But hopefully, the only thing that's not on the first page is escrow agent. That's still on the second page, but we'll keep looking at ways to make that first page as efficient as possible for you guys, so you're not having to, paw through too much of the contract to find important terms. Yeah, I'm ready for the next slide. So this change here is on the second page of the contract, and it, at first glance, it may not seem like a big deal, but it is. And so let me just talk about it a little bit. The old language, there's no strikeouts in here just for readability's sake. If you go through and look at the old language, there were some escrow agents who used to interpret the old language as requiring a written agreement between the buyer and seller in order to release the earnest money deposit. But that's not really how the law reads in this arena. Really, the law focuses more on, is there a dispute or not? So if you got a scenario where, it's clear who the earnest money should go to, and, either the buyer or the seller has disappeared, then it would seem that there should be a way to try and get the parties, their earnest money back when it's clear. And so a lot of times when people call the hotline with this particular question because somebody's disappeared, I usually tell them, try sending an email, send it to the other side and say, listen, unless your client demands, the earnest money within 48 hours, then we're going to presume there's not a dispute. And then, and then if there's no response, then send that over to the escrow agent and see if that's enough for them to release the earnest money. Sometimes it's not. Each escrow agent is fully entitled to have whatever procedures they believe are necessary to keep in place in order to not run afoul of trust account rules. Those of you that deal with trust funds, it's important. So, each escrow agent is certainly fully entitled to adopt whatever they feel is necessary. But hopefully, adopting this language, as you could see, it says in the event of a dispute. If there's no dispute, then it should be up to the escrow agent how they want to address it. So, but in the event of a dispute, then it talks about what will happen to the earnest money, clerk of court, potentially a lawsuit and things like that. So just be aware that that language has been changed. If you've got a closing attorney who's demanding that there be a written agreement between the buyer and seller, then point out, that this language has been amended and that, that's not quite it. It's really just a question of whether there's a dispute or not. And maybe focusing on that will, resolve some of those scenarios. Okay. Here we've got fixtures and exclusions. We got some new language beside paragraph 2 here that's in red, and it'll continue to be in red in the final version of the form. But, it's really just making sure the parties are aware that they shouldn't assume that something in an MLS listing is automatically going to be in the contract. And, for that matter, letting agents know that too. So make sure that both understand that that's the case. So that's new language there. Paragraph 19 that's referenced right there is really a reference to the merger clause later in the paragraph, which basically says, this is the entire agreement of the parties. And if there's going to be any amendments, then that amendment also needs to be in writing. As for the bullet points, no big change there. The reason they're highlighted is that now they've been made to match exactly what's in the exclusive right to sell listing agreement. So in paragraph B here, let's see. Yeah. So this is down in the, I can't remember the number, but it's the buyer representations paragraph. So you see a little bit of language added here to make it a little bit more clear that, this is just a disclosure by the buyer because it's under, the paragraph for buyer disclosures. And so there's not any sort of contingency in this contract for the sale of buyers of the property. If they want that, they got to get a custom addendum. This before there was language that was akin to this, either in a note or warning on this same page, same section, but hopefully moving this out, moving it in there, and also having a little bit of bolding and italicization will make that a little bit more clear so that people know. Now, granted, I don't know, I've been getting more hotline calls on contingent sales and how to do that and where to get, contingent sale addendum. I've gotten 2 phone calls today on it already. So it's something that may be, on the radar because those of you who've been practicing a long time know that we used to have a contingent sale addendum and that form was retired quite a few years ago. So in any event, we don't have it, but if it's something that you want to have a custom addendum made, then certainly you could do so. Next, we got under the buyer obligations paragraph. This is a restructuring. You can see in Romanet I that this is something that used to be on the top of page 2, but if it now it's not. Now it's way down on page 6, which is probably a more appropriate place for it because come on, buyers, pay your money on time. Why do we got to talk about what we're going to do if you don't pay your money on time? Just pay your money on time, right? Yeah. In any event, so here we've moved the mechanism for one banking day down to page 6 and Romanet I. You see form 355 is referenced there. That is the form you can use to make a demand. The other sections of this are nothing new for this particular paragraph, but they've been sort of broken out a little bit to make them easier to read. Next up, we've got not a big change here, but one that hopefully saves you guys some paperwork because, heaven knows you guys are paperwork to death already. So you don't feel like you need to fill out the association 2 times. If you only got one association, it's just association 1. So designating those 2 spots as 2 different associations hopefully will save on people filling that out twice who think that they, need to. But otherwise, even if you're working on an old form, remember you got 60 days to make the switch from the old forms to the new forms. So, if you're on an old form, just know if you've got one HOA, then you only got to fill this out once. But if you got 2 different HOAs, fill it out for each one. And then we got the guidelines. Like I said, we're not going to cover this in any detail, but there's, as you can see, just from the first little snippet here, there's going to be a lot of changes because the form has changed so much, number one, but also I thought Forms Committee did a really good job of, taking some things and from the Q&As and bringing them into the guidelines as well, just for ease of use. For example, in paragraph 2A of the guidelines, now you've got the factor test, the 4-part factor test for fixtures. Because there's 2 ways something can be a fixture in the contract. There's 2A, which is just any fixture that's normally considered a fixture under the law. And then 2B is where all the bullets are. So there's 2 different ways that something can be a fixture in the contract. And so putting that test into a, it's right there for your reference if that's something you need to talk to a client about. So there you go. There's the offer to purchase and contract.
Okay, thank you, John. Good afternoon, everyone, and I want to thank you for taking time out of your important day to join us. And just a couple of quick things before I jump into these forms. First of all, I do want to let you know it's an honor to serve the membership, and it's an important committee that I've proud to have been a member of for so many years. And also want to thank Amy for her past year. Amy, really, it will be a tough act to follow. So thank you for everyone and for the members on the committee. So we're going to rat-a-tat-tat here, some forms, some minor changes, and I think we can go through these fairly quickly. The buyer and seller, the first three, seller possession, buyer possession, and additional provision addendum all have the same type of change. And it's where the seller in the seller possession agrees to comply with Section 2C, which says you will unpair all data related, all smart devices by closing. So in this case, it's by the end of the term. And we'll go on to the buyer possession. It says the same thing prior to commencement date, and then we'll just flip right over to additional provisions addendum, where it says same thing down there, except now this is specifically under number 3, which is the rental income investment property provision. And it says, except for any devices under a tenant's control, which maybe perhaps that's the HVAC or something of that nature. And this is all language prompted by the fact that over the last few years, smart devices, smart homes, they're all becoming more equipped, and it's becoming more of a talking point at the time of contracts, and particularly at the time of closing. So keep those obligations in mind. All right. The Owners Association. So go ahead and flip that over, Amy. So there's a couple things here. Amy, actually, if you go to the next page and let me come back to this one. So the first change here was done. We just reformatted this. It hopes to avoid what we were seeing is that both sections were being completed, even though there was only one HOA. So no need to repeat that, particularly if it caused a problem. It was conflicting information and it was the same HOA association. So we've done this in hopes that if there are two associations, for instance, community with single family and condos, typically there's a master HOA, and then you'll have one for condos. So you can separate those. So that's a format change only for that purpose. And Amy, if you go back to the previous one, thank you so much. So this was interesting. Discussion came up during the last cycle that due to the change by the real estate commission when they reformatted, did the R code, one thing that was missing, and that's another discussion for another time, but one thing that was missing were the checklist of items that your HOA fees covered, services and amenities. So what we saw was the membership beginning to use this addendum, which still had the space for those items that you could specify what that $300 a month covers. So since it was being used, and it's going to be used anyway, we eliminated this language up here that says, hey, this is to be used only for these times when an R code is not required. So let me reiterate, it can be used. We're fine with it being used for any transaction. It's not mandatory. You're likely to run into some listing agents who may or may not have it as an attachment to a listing. Listing agents, you may or may not run into a buyer who would like to submit it, a buyer's agent on behalf of their client, to have it filled out and have representation done by sales. So it's all be negotiable. So we were seeing an increase, and I suspect we'll continue to see an increase of this addendum for that, primarily for that purpose I just mentioned. Okay. Agreement to amend contract. I've always said for years, well, the forms committee a while back, they had a really good day with the agreement to amend. We love this form. So we've tried to improve it. And there's a couple of things. First of all, the additional buyer was well received. The lenders in particular seem to be happy with this if we had to add a buyer for loan purpose. So we thought, well, how about if we have to remove a buyer or a seller for a loan purpose, or perhaps if it's incorrect the way an estate is filled out, something of those reasons. So we think that the lenders and hopefully attorneys will find this to be satisfactory if that has to be done in your marketplace. So we've added that. And then I think we've cut off, so I apologize for that. There's also just a small change on the due diligence period. And the text change is just a couple of words eliminated. So that it just allows you to change the date, not an extension. Because we realize, that, hey, sometimes it's part of negotiations for repairs, perhaps. Sometimes part of that is you'll shorten the due diligence date to get a concession. So now the way it's worded, if you've not already seen it, you will. It allows you just to change the date, whether it's to extend or to shorten. So I think that's a good practical change. And with that, John, I believe we're handing it back over to you, buddy.
Yeah, let's get into the exclusive right to sell listing agreement, Form 101. You can see here, not a lot of changes to this. There are some extra lines for other fees. Make sure, again, as a reminder, that, firm's fee is separate from cooperative compensation. Okay, you should be having a separate discussion with your seller about what your firm is going to be receiving as compensation, as opposed to cooperative compensation, which is a separate discussion point. So I've been getting a lot of calls in the hotline of different ways to fill out these sections. And really, truly, the boxes, the other fees line, all those different, features of this form are meant to give you the flexibility where you can make this form work however your firm would like. The only thing that I would stress about it is that, you always want to make sure that I know one of the driving forces, especially for the rewrite of this form this past January, is to make sure that it's easier to understand, easier to use, both for consumers and for agents and firms, and having a discussion, a very in-depth discussion about, what your seller is going to owe your firm for your services compared to what the seller may be able to negotiate with cooperative compensation, if at all, with a consumer or a cooperating agent or a buyer. That is something that should be two separate conversations and be something that you cover in depth in a way that the client can understand. I can tell you that my in-laws just sold their house in North Carolina, and their agent did an excellent job of explaining it. It allowed me to surreptitiously see how these conversations may be going in real life. I think you guys are really doing a good job with that. Especially with the way the new forms are. Settlement compliance is something that is going to continue to be a top priority, both from MLS standpoint, from local board standpoint, state standpoint. There is nobody that wants to try and be out of compliance with the settlement. And this is one of those things where if you really want to make sure that that is your focus of your firm, then having a separate conversation on firm's fee compared to cooperative compensation is an important one to make sure that you've got incorporated into your practice.
Hang tight. User error.
All right. Thank you. Here you can see no big change to the cooperative compensation section, but what I do want to do is just there's some language added in the first checkbox there to make it clear, that cooperative compensation is in addition to whatever is firm's fee. And these Romanettes below 1, 2, 3 right there are something that I've been pointing agents to on the hotline when they're asking, well, why in the world? Like, if we're not putting some sort of larger amount that I'm sharing for firm's fee for cooperative compensation, if it's two different things, then how is the seller supposed to pay? And that's what those Romanettes are. And mind you, these boxes right now, the way that they're structured, the first two boxes in 7C, correlate with Form 220. That's the point, the intent, and the purpose. Is it going to be the firm or is it going to be the seller that's offering cooperative compensation? And so those two check boxes really give you the authorization to go out there and advertise what the seller may be open to offering, or the firm. But even if the firm is offering it, Romanet I makes it very clear that the seller is going to be paying the firm at closing, and then the firm will turn around and share that with the cooperating agent. Really, the way you can think about these check boxes is like the first check box is a situation maybe with a seller who, they just want to sign the listing agreement and they want you to go do your job and sell the house. Like, they don't want to be, super involved with that. And they just want to give the firm the authority to offer it, negotiate it. Still, of course, I know you guys, you are definitely going to, run that past your seller. It's not something that you're going to do in the dark. But as far as who's really going to negotiate, it's the firm that's going to be offering and negotiating it on the seller's behalf, which is truly no different, not a lot different than it was before. The second box is where the seller is going to be offering the cooperative compensation, which means on Form 220 in that first paragraph, then the seller checkbox will be checked instead of the listing firm. And then the seller may offer that amount, and you want to know what that authorization is, what it's up to, because that's what you would want the authorization to be. You don't want to be a listing firm out there advertising that there's a potential for cooperative compensation and your seller hasn't authorized it. So that's really what the second box is, even though the seller is going to be the one checking that box in Form 220. Then in the first paragraph, you still want that authorization as a listing firm. So that's really what that's about. So these are more technical edits. Down at the bottom, you see total cost has just been changed to optional. That's because if in firm's fee, in the first part that we looked at on the previous slide, if you've got different amounts in there for unrepresented buyer or dual agency or things like that, like if your firm, has an agreement with the seller to get paid certain amounts for these different scenarios, then honestly, total cost is going to end up being some kind of range or something like that anyway. Maybe it's not something you really want to fill out. So that's why instead of putting, a computation there, I think the computation is still technically the same. It's just that it was something that Forms Committee felt like it was more appropriate to label as optional and then let you guys fill it out how you felt appropriate as far as letting the seller know exactly what their potential obligation would be. So.
Hey, John, while you're right here, we've got a question about the second checkbox, the may offer, the idea that that may be conditional. Can you speak to that a little bit?
Well, it's just the seller, may offer it, and that means that I guess there's no real. I've answered this question a couple of times. There's no like mystery to solve about authorized, firm is authorized compared to seller may offer. Okay, it's really functionally the same kind of language. There's no, at least, I don't know. I can't remember the discussions exactly on Forms Committee, but to my recollection, there wasn't like a big discussion point between those two. But that said, because it's a question I've had to address enough, it might be something the Forms Committee wants to look at to see if they want to make it the same. Or I guess it also sort of depends on whether multiple listing options for sellers, how that pans out with MLSs across the state, that will probably also affect this too. In any event, the seller may offer, that amount, and it's going to give you the ability to put that out there. But really, truly, what it's getting at is, you on each offer, the seller may or may not offer a certain amount. It's not necessarily a blanket offer. So I guess what I would say is it's more about what goes in those blanks for the second checkbox is really what the listing firm can tell buyer agents. It doesn't obligate the seller to offer anything. And this was true in the old forms too. There was an authorization in the old Form 101, but it wasn't mandatory. Just because there was something in there didn't mean you had to offer that. So I don't know if that was kind of a roundabout way of answering the question. I'm not sure if I got it exactly right or not.
I think you got it right, and I'm answering a few more questions in the chat. Let me get you moving on.
All right. So here we have an addition. This is from the old listing agreement, moving it over into the existing one. Just making it clear that if there's a transfer to a business entity, then it'll be something that you still will be able to have your compensation earned and payable. Here, we have a technical change to the dual agency section to make it match exactly what was in the buyer agency agreement. So now they should be exactly the same. Yeah, that was just I'll take the blame on that one. That was an oversight on my part. But it doesn't function any different than the buyer agency agreement. Here, paragraph 16, I know a lot of you will be relieved to see substantial edits to this. And I just want to say that this is one of those things I think where, because the buyer is just not a party to the listing agreement. I think it was something that when you read the original language initially, because the buyer's not a part of the listing agreement, then no, it doesn't have anything to do with, potential buyer inspection costs and whether the seller has to pay for buyer inspection costs. But once I started, receiving feedback on the hotline about it, I was like, oh goodness, all right, I see what you're saying. Okay. And I apologize. I'll take the blame for this one too. The true intent of it always has been from the beginning, from January. It's just not fair, when I get hotline calls and a seller is got you out to the property, done the listing appointment, they're all ready to get the property listed and all get the property sold and all this stuff. Of course, you guys are doing your job, you are hopping to it, and then suddenly you've got a surveyor out there or somebody coming out and doing work, somebody you've had a relationship with them for a long time, and then the seller's just like, nah, never mind, I'm just joking, I'm not going to do this, I'm not moving on, I'm not going to return your phone calls. Well, that's not fair. And I've had phone calls before where it's, a surveyor has been out there and he's like, hey, the seller's not paying me. The seller's not communicating with me anymore. You going to pay me? I mean, somebody's going to pay me. Somebody called me out to this property. And granted, yeah, the surveyor has options, right? They have options to be able to go over after that money. But, at the same time, that's not a relationship that you felt like, jeopardizing on behalf of any particular seller client. And that's really what this is about. You guys spend a serious capital in developing these relationships, and it's not something the seller should be able to take advantage of. If they direct somebody to go out to the property and you're out there helping them do it, then you shouldn't be stuck with either a damaged relationship with that vendor or with potentially a bill from that vendor and having to explain that. So that's really what this paragraph has always been about. Hopefully these changes will make that very, very clear and that they have nothing to do with buyer inspection costs. All right, yeah, so the guidelines to Form 101 and 201 have both been redrafted, so check out those. A lot of good information in both of those forms. Vacant land listing agreement now looks the same as Form 101, so feel free to look at that. The Form 103 had not been updated yet, so now Form 103, the vacant land listing agreement, looks the same as Form 101 as far as style goes. And then finally, we didn't go over this specifically in Form 101 or 103, but the Internet Advertising Addendum. So in the public advertising section, there's a reference to the Internet Advertising Addendum Form 105. But again, with the multiple listing options for sellers, rule being considered, and as far as its implementation and things like that, a lot of the things in that form didn't make sense. It wasn't a very commonly used form. So it's been suspended for bad behavior for the time being.
All right, I'm going to jump back in with the estimated net to seller spreadsheet. This is one where we had a specific subcommittee to really kind of rip it apart and build it back. So you'll see at the top of the form, we wanted the form to progress the way you would progress through a transaction. So the things that are at the top are now the pre-marketing expenses. So money a seller is going to potentially pay before they go on the market. Are they doing a pre-listing appraisal to help determine a listing price? Are they pre-inspecting the house? Are they painting or replacing carpet, right? So you can show them how those will affect their net at the end. So you could use this if you were, say, showing a seller, here's if you were to sell it as is, and here's how I think your numbers could look at the end, versus if you spend some money fixing up the house or doing some repairs, here's how I think your numbers could look out at the end. So you can sort of use it for both of those. The next section is the mortgages and liens. Probably biggest update to this section is we very specifically called out fixture liens and very specifically named solar. It's becoming more prevalent that sellers have solar panels and may have liens that need to be paid off at closing. So calling those out so that they realize those things need to be paid off. And then closing expenses down here. We have very specifically broken the listing firm compensation apart from potential seller sub-agent or buyer agent compensation, so cooperative compensation, because those are two totally different numbers. We also have a line in here for compliance, admin, brokerage fee, whatever, they could be called, because we're seeing more of those in the marketplace. And I think that's about it. We also changed the order at the bottom that the due diligence fee is now above the net proceeds. So the seller sees that they'll have already received that due diligence money, and then, what their number is after that. And then, John, I'm going to throw it back to you. You are muted, John.
Oh, exclusive buyer agency agreement form 201. Yeah, I have to, like, I've got to be very diligent with my muting right now because I got construction on the other side of the wall here from me. And so sometimes it's like blaring music and other times it's like pounding. And, it's like the inside of my head just to be manifested across the wall in any event. All right. Exclusive buyer agency agreement form 201. We got a couple changes we're going to go through in this.
Sorry, typing questions.
Yeah, no, you're good. So fee for services, we got a little indicator here, unless otherwise indicated below. And the reason for that is because, the buyer agrees to pay firm all of them. So we wanted to put a little moniker in there to say unless otherwise noted below, because now there's a checkbox for bonuses if it's offered and paid by a seller or builder. So it's not something the buyer's going to be obligated to pay. Check all the boxes that apply. All of them together are what will be the fee for the services. When it comes to a bonus, it's no different than anything else as far as MLS rules and the license law is concerned. It's got to be a specific amount. So put a specific amount in there. And, I would put it toward the high end of whatever you're seeing in your market. If it ends up being less, then under the settlement, accepting less is not an issue. But trying to amend a buyer agency agreement to get more, you cannot do an amendment to get more compensation in a buyer agency agreement unless that amendment itself complies with settlement rules. And there's a Q&A on that. I'm not going to get too far into the weeds on that issue, but if you know the link to that Q&A, I'd be happy to send it to you. Here we've got, it was a little bit below the fee for services paragraph, the mutual termination required. That paragraph has been stricken out and it's been moved down to paragraph 13 to match the listing agreement. Listing agreement came out that way. And here's the thing is that, yes, it's something where in order to actually mutually terminate, the agency agreement, then yeah, you would need two people to sign. You need the client and the firm to sign off on the termination, right? But what happens if you just got an issue with a client who's breaching the agency agreement and you want to know what your options are? And your options are everything that you're entitled to under regular contract law. So what are those things? Well, a non-breaching party under contract law, you can elect what remedy you want to seek. You can see if you try and force the other side to perform. You can elect to receive damages for the breach. There's all sorts of things you can do. And in older versions of the agency agreements, there was language about, legally sufficient cause, and there was a requirement for mediation. In my practice, most of the time when agents came to me, looking to enforce an agency agreement because a client was breaching it, they'd already messed up the mediation. They brought the lawsuit in their personal names to the firm. There's all sorts of little landmines that the old language used to create that to me just didn't seem necessary. So if you've got a situation where a client is materially breaching the agency agreement, you have all sorts of different options under North Carolina contract law, standard contract law. So that's what this language is really meant to do. If you can terminate by consent, great. Then that's how you can terminate it. Otherwise, if the other side's in breach, that's not addressed in here because it is part of the contract law of the state, and you can talk to your lawyer, whoever that may be, to see what your options are if you got a client who's breached your agency agreement.
Oops.
Yeah, so as I said, 201G, it's been redrafted, so that's out there. Make sure you take a look at that at your convenience. Probably my favorite part of this latest round of forms changes is this next part here. We're going from, 6 termination forms down to 3. So you will have 350, 352, and 390. So 350, that is the unilateral termination form from the buyer to the seller. 352 is from the seller to the buyer. And then 390 is if you can negotiate an agreement to terminate, then use that. If you cannot negotiate an agreement, so for example, if you're a buyer agent, you reach out to the listing agent / seller, say, hey, my client would like their money back. Can we do this? If the seller says no, then don't send Form 390. Don't do that. You don't have an agreement to terminate. There's nothing to sign. Don't do that. Use one of the unilateral termination forms because Form 390 does now in the old forms and still will going forward a legal release. So if you send that, number one, you're creating ambiguity about whether the contract's terminated or not, and that's not good. You want clarity on whether the contract is terminated or not. And then number two, you've got a question of whether the legal release is going to be effective or not, and that's not good either. So if you can negotiate an agreement to terminate, then Form 390 is the form to use going forward. Otherwise, it's 350 or 352. So let's take a look at 350. Yeah, you can go to the next slide. So here you got the unilateral termination from buyer to seller. That just means one side signs and sends it. You can see there's all the regular checkbox options through here, but then you've got Form 2T only, right? So then you've got one specific to 2T, and then you've got one specific to 12T, which is the vacant land contract. So you got those two options. Otherwise, all the same boxes are there. They overlap with each other compared to the old forms. One real good feature that I think is in this form now, though, is that the buyer can give notice of termination without giving a reason after the expiration of the due diligence period, and they can do a checkbox of whether they do or do not agree to release the earnest money deposit. So maybe that'll help out some sellers who are entitled to the earnest money. And then maybe the buyer will sign that before they disappear. I don't know. It's a hope. Release of earnest money deposit, you still have, that at the bottom of the form, and you can see that the seller, whenever they do or do not agree to release the earnest money deposit, the seller still reserves all rights to dispute or challenge any of the check boxes that are above there. All right. Next, you got Form 352. This will be from the seller to the buyer. If you ever wanted a checklist of when the seller has a right to terminate, you can see it's the first 4 check boxes there in paragraph 2. But otherwise, it's substantially the same as it was before.
Sorry.
Okay. Yeah.
All
And
right.
then
Oops.
one more.
One more. There you go.
There you go. Nope, too far.
Too far.
Yeah, go one. There we go. And then you got the release of the earnest money deposit at the bottom of Form 352. Okay, yeah.
My mouse got squirrely.
It's all right. It's squirrely like one of your clients, I'm sure.
Yeah.
All right. And as I mentioned, Form 390 has been updated. So it used to be there's 2 forms to agree to terminate a contract. There was Form 390 and Form 391. Form 390 was an agreement to terminate when the earnest money, when there was an agreement also of what to do with the earnest money deposit. Form 391 was a form to terminate when there was not an agreement on the earnest money deposit. So how do we merge those two together? Well, we do it in paragraph 4. So as you can see at the top, we got seller, buyer, property, we got the contract, we got termination. Then in the paragraph 3, we got the legal release that I mentioned before. Paragraph 4 is where these two forms, these two old forms merge together. And you can see the buyer and seller either do or do not agree how the earnest money deposit should be dispersed. So paragraph A, if they do agree, then disperse it, so much to the buyer, so much to the seller. Okay, cool. Great. Perfect. If they do not agree, then they can agree to terminate the contract, but, they're going to save the earnest money deposit out. They have all rights and remedies available to them for the earnest money deposit. They can agree to terminate on other terms, effective date. So what happens if, they sign all this, they do not agree to the earnest money, what then? Then you have an earnest money release at the bottom. I think that's probably on the next slide. Yeah. So at the bottom of Form 390, you've got this release of the earnest money deposit. If they have already agreed, you don't have to fill out, this part twice, okay? You don't have to have it filled out twice, sign it twice, and all those things. You can just fill it out if they do agree in paragraph 4A and just leave this part at the bottom blank. Like that's perfectly fine. Or strike it out, whatever you want to do. But if the parties do not agree, and then they later do come to an agreement because they figure out how much of a hassle it's going to be to go to court or whatever, then you can sign. There's a below the spotted line there, the checked line, whatever, hyphenated line, I don't know, whatever you want to call it. There's a line at the bottom. And then underneath that, you have this release of earnest money deposit. And you can see buyer and seller have now reached an agreement as to the earnest money deposit after signing the termination above. So you can see that first sentence there makes it clear that you're only going to sign this if they can't agree on earnest money at the get-go, but now they do.
Steve, you're up with the agency agreement amendment.
You got it. And before I get into this, let me just say, I think at the end we'll have some extra time to go back. There's going to be, I think we probably need to have some 220 clarification discussion on that with some questions. Also, I think I probably poorly worded an answer and kind of just expound on that some. But so hopefully we'll have time to revisit that as a panel here. Going on to agency agreement amendment 710. So 710, the amendment was amended. It started with the elimination of Form 770 for a lot of reasons. And then 710 was amended to accommodate, to work in unison with the revisions to Form 101 and 201. There's a section to easily change dual agency with a client. Lines have been added to change permissions and cooperative compensation, so they can be amended. That's the position right now that can be amended, and it's an easy way to do it. And for formatted, we've added check boxes because I think over the years we found check boxes are well received, easier to use, understood. So we've also added some check boxes, and there's an amendment number. Amy, if you go back up for a second, there's an amendment number also at the top of the form, so that, like the agreement to amend, you could have potentially multiple ones of these for different reasons, and you can number these like you can the agreement to amend. So that's the restructure and reformatting of that form and some additions. We think that'll be a great form. And now I think it's back over to you, Amy?
Yeah, I'm good to talk for a little while. So we had some fun and created some new forms for you. The first one is the statement of agency relationship and compensation. We were hearing from, and even some of us on the committee experiencing, situations where a mortgage lender, an attorney, a builder would ask for copies of your buyer agency agreement to see what compensation was agreed to in that agreement. Some agents, potentially rightfully so, were hesitant to give over that full agreement because it has confidential information between the agent and the buyer. So this form essentially serves as a summary of that agreement. So you can give just this to the builder, the attorney, whoever, as opposed to your entire agreement. And then John, will you speak to if this is filled out incorrectly and doesn't match the buyer agent agreement?
Yeah, so if this is something where if you make a misrepresentation on it, certainly you could potentially be disciplined. So make sure you're filling it out accurately. But it doesn't amend a buyer agency agreement. So, it's one of those things where it has teeth, but the teeth are not, something that's going to amend a buyer agency agreement.
Great, thanks, John. And then Steve is going to talk about another new form, Form 804.
My first abuse of power was to give myself the easiest ones to do today. So there we go. And this is a new agreement to amend the 800 form. New construction OTP was vastly had a huge overhaul a couple of years ago. So we needed an agreement to amend to match that form. And that's exactly what this is. It's a new construction version, Form 804, specific to the 800 OTP. So, and we hope it's useful.
And that concludes our summary, but we do have some questions to go through. John, if it's okay with you, I'll go through and kind of shout the questions out, and then any of the three of us can kind of grab them. I imagine that a lot of the compensation ones you'll probably take, but let's see how this goes. How is buyer agent rebate handled on the buyer agency agreement, if at all?
Rebate?
Yeah, if an agent wanted to agree to give some of their compensation back to the buyer as a credit.
Yeah, I mean, you can put that in the other terms. You can always share your compensation as an agent. You can share your compensation with any part of the transaction. So if you're a buyer agent, you can share your compensation with the seller or the buyer, either one. Doesn't matter if they're licensed or not. So I guess what I would say is that when it comes to rebates, if that's something you've agreed to up front, then put that in, the other terms section on page 3.
Great. If a buyer terminates during the due diligence period, does the seller have to sign to release the earnest money?
It depends on the escrow agent. And I'm not sure how escrow agents will deal with that sort of a scenario going forward. There will be times, where a seller, for whatever reason, even though the buyer terminates during the due diligence period, they will say that they're entitled to the earnest money. And if they, register a dispute with the escrow agent, even if, their claim to the earnest money is not good, it's something that they can pursue nonetheless. So I don't know, that's kind of a difficult one to answer.
Another one is, why would a builder, roofer, or other vendor need to know buyer agent compensation? Well, a vendor or roofer would not. Really, we're seeing this request from builders, mortgage lenders, or closing attorneys. So people involved in the transaction. Mortgage lenders are asking for it, especially in the case where the buyer is paying some of the compensation. The lender wants to see that that was agreed to before they'll allow it to be put on the closing statement. Builders, it's kind of a new thing. I don't really know why they're asking for it. I think it's just in this new world post-settlement, they are kind of feeling their way through things, and they want to make sure that what compensation they're offering does not exceed what you have agreed in your buyer agency agreement. Anything to add to that, John? Let's see. On the amendment to agency form, can you explain the last checkbox? It seems like it would be checked all of the time.
Yeah, no,
You know what he's talking about?
yeah, these forms go through, they don't go final proofing and, before we do the things that is not fixed yet, it is in the process of being fixed. Yeah, that checkbox just needs to be removed.
Got it. Which form, or should you use an addendum if there is a bonus for new construction?
If there's a bonus for new construction and you're the buyer agent, then it needs to be in the buyer agency agreement. If it's something that, if you're asking what form could you use to accept that, if it's already in your buyer agency agreement, then, and you want to do an agreement with the builder, then you could use 220. That would certainly be an option.
There is a question about how the total compensation, I think they're maybe referring to the listing agreement, could potentially be a range if we have to give specific amounts.
Yeah, so I guess what I would say on that is that if you're a listing firm and you've got one amount of compensation, if you're in the transaction, and then a different firm, is the cooperating firm, right? You got one amount of compensation in there for unrepresented buyer. You got a different amount of compensation in there for like dual agency. Like you could have 3 different, or any number of different specific amounts of compensation that the listing firm will be paid depending on the scenario and who may or may not be on the other side. So that's why that, total cost line to the seller can be a range. It's not actually a range. Depending on the scenario, you can exactly tell how much the seller is going to pay, right? And so it just ends up being a range because there's these schedule of fees depending on the circumstances. So that's really what we're getting at.
And I just want to say that that was it was at least one of those kind of questions I answered a little incomplete, and I think that created some confusion. So thank you, John. That's exactly the scenario there. Yes.
Another question. So if you have a certain amount agreed to in your buyer agency agreement, but the seller is offering more, this agent says they were told to put in additional info, the name and address of the house, and that additional or different amount, it sounds like. Is that correct?
Probably not. Like I said, amending a buyer agency agreement after you've gone through, what your services are going to be to the buyer. You've agreed to a certain amount of compensation with the buyer to get paid for those services. As I said, unless you cannot amend. It's never been the case under the settlement that you can amend a buyer agency agreement to match whatever the seller's offering. You're supposed to, and the license law has been sort of akin to this too. But it's under the MLS rules, it's a little bit more strict than even the license law is, although they are substantially similar. In any event, unless your amendment to your buyer agency agreement actually conforms with the settlement itself, then it's something where you wouldn't be amending a buyer agency agreement simply because the seller's offering more cooperative compensation. That would not be permitted under the settlement.
Kind of to piggyback off of that, someone said if there's a potential for a builder bonus, they would need to put that in their buyer agency from the beginning and specify a specific amount if they think a builder might be offering a bonus, and they have to do that up front.
That's
Is
right.
that correct?
Yep.
Fantastic. Let me find you. If your seller agrees to an amount of cooperative compensation in the listing agreement, but later wants to change that, is 710 the appropriate form to use for that change?
Yeah, yeah. You could use 710 for that.
Great. Let's see. There's just a land. No, it's not. Let's see what else we got here. That one's already answered. Can you put in section 12, I believe they're talking about on the buyer agency agreement, that buyer chooses to see only properties where seller or seller's agent pays buyer agent commission?
Yes.
The answer is just a noise.
I just don't like it. I just don't. I don't think that's good for the consumer. I understand that, a buyer may be limited in their funding, but they also want the services of a buyer agent. Yeah, I don't know. I think that's, it's just a difficult thing. But that said, you know, if you really, I think a better way to actually approach it would be, and this might be something for next cycle to think about, but in the non-exclusive buyer agency agreement, Form 203, there's a checkbox option where the buyer can, and the buyer agent can agree that, unless there's cooperative compensation offered by the seller, then essentially the buyer agent's not going to get paid. That is not in the exclusive buyer agency agreement. But to me, it's just one of those things where if you're writing things in like that into the exclusive buyer agency agreement, and then something goes wrong, I think it's something where you could potentially be looking at discipline from the license law. I think it opens a firm who would have a practice like that to potential antitrust allegations. It's just, to me, I guess I would put it this way, can you do it? Sure, you can write those words in there, but you better be consulting with a lawyer about all the risks that go along with potentially having a policy like that. So it's just one of those things where you're not going to have me just, giving you a blessing on that, it is just too much risk associated with a policy like that.
To kind of expand on that, can the buyer agency state a range of compensation? To that, I will say no, it has to be specific. And also specify that the buyer is paying the fee. So, John, I think to that you would say that's what the buyer agency says. That's the purpose of the form. At the end of the day, the buyer is responsible for the fee that is agreed to. You could seek compensation from a seller or builder to go towards what the buyer owes. But at the end of the day, the agreement says the buyer owes.
Yeah, in Form 201, but like I just said, Form 203 is totally different. So if you want to do a non-exclusive buyer agency agreement, there's a little bit more flexibility in there.
How do you handle it when a listing agent asks the buyer agent to create Form 220 and send it over with the offer?
That's fine. 220 is meant to, it can come from the listing side or it can come from the buyer side. So either way.
I think the question may be stemming from it has sort of been ingrained in us as agents pre-settlement that compensation was never to be negotiated at the same time as an offer. John,
Yeah.
am I correct in saying that in reality, it was simply that it was prohibited to put it in the offer form, not necessarily the negotiation of the amount?
Yeah, it's interesting. Code of Ethics expects that you'll ascertain cooperative compensation, if any, prior to a purchase contract. And yeah, I mean, it can be all part of the same negotiation, especially now, that the law has changed on this. This it's going to be I know for a lot of people, it's going to be a major shift yet again, as if you haven't had enough major shifts. So for the last year and a half. But yeah, it's going to be a major shift. But it's always been the case where, yeah, if you want to seek a particular amount of cooperative compensation because your buyer agency agreement has a particular amount, if you want to put that in 220, you can and send it along with the offer at the same time. This is all in Form 220G. If you haven't looked at that flow chart, that's, if you want to keep proceeding with that, you definitely can. It'll still work, even under the new rules. So that's fine. But also Form 220, there are listing agents that they sit down with the seller as part of the listing appointment, and they fill that out too. So, and that's also addressed in there that has certain there's certain things you have to address when if that's your policy, but that's in Form 220G as well. So.
Another question, in section 7 of the listing agreement, why is there an option for both the firm offering compensation and a seller offering compensation when, if in the end, the seller is paying either way?
Yeah, I guess, correct me if I'm wrong, but this is my recollection from the forms committee. So Steve and Amy, if I misstate this, you can skewer me if you wish. But, you can think about, the first option where the firm is the one given the authority up to a certain amount to negotiate cooperative compensation. You have a fiduciary duty to the seller, so you're going to go out there and negotiate cooperative compensation in a way that is to your seller's best interest. And you're just going to go out and do it. You got the authority. It's not something where the seller is going to be potentially, I mean, you want to get their final green light at the end, of course, as a best practice. But at the end of the day, you've got authority. They've given it to you to go out there and negotiate it. And so you can think about it as the seller's just not quite as involved with the first checkbox, where the listing firm's offering it and negotiating it. But the second box, that's really just for you to be able to put information out there for potential buyers. But ultimately, seller's the one offering it, signing off on the 220. They're going to be a lot more involved in that process. And you're going to have sellers that may want more control over that particular part of the negotiation. So that was the discussion that was had in forms committee. And so that's why it ended up, shaking out that way. Or you can just, attach your own policy. That's the third checkbox. I'm not sure how many people actually do that, but I presume someone is, maybe. In any event, what I would say is that's kind of the thought process behind the two. Is there a lot of functional difference money-wise between the two? No, but there is one very important difference, and that is under Form 220. And this just came up today on a hotline call. if the seller is the one agreeing to pay the cooperative compensation under Form 220, if they end up breaching, then they are going to be liable for not only their listing firm's commission, but potentially buyer agent commission too. And it's because they are the contracting party under Form 220. Whereas if the listing firm is the contracting party in 220 instead, then paragraph 3 makes it clear that the listing firm is not going to have to pay cooperative compensation if the seller breaches. So it's a real big difference. I talked to a buyer agent earlier today just on this particular subject. So that part is very different as far as who the contracting party is in Form 220. So in the listing agreement, is it that big of a thing? There are a couple different ways you could think about it, but in Form 220, it becomes a real big difference.
If the seller has agreed to pay a certain percentage to the listing firm on the listing agreement, and then another percentage to a buyer agent, if a non-represented buyer ends up purchasing the property, would the seller only owe the firm's fee and not the cooperative compensation? We've stumped him.
Say that again.
So if the seller is agreeing to pay the firm X and agreeing to offer cooperative compensation of Y, if an unrepresented buyer purchases the property, so there is not a cooperating agent, would the seller only owe X, the firm's fee, or would the seller owe X plus Y?
Just the firm's fee. So if you want something different for an unrepresented buyer, then that would be something you put on the other fees line in the firm's fee section. You would have a different amount in there for unrepresented buyer.
A couple of questions about 220. I'll sort of group them together. So after the settlement, agents were very much told to try and firm up Form 220 as early in the process as possible prior to submission of offer. Is that still something that you feel needs to be done prior to offer, or do you feel it's just fine to negotiate that 220 at the same time as the offer?
I guess here's how I would answer that. If I'm either a listing agent or a buyer agent. Well, no, let me take it from the listing agent side. If I'm the listing agent, I want to know what the offer is before, like the purchase offer terms are before I put an offer of cooperative compensation out there. Because chances are, I mean, it's not in the best interest of my seller to just willy-nilly offer an amount of cooperative compensation no matter what the offer is. You know what I mean? So you want to put it out there that even if there is cooperative compensation available, then whatever amount it is going to be conditioned on an acceptable offer. So to me, logically, the most efficient way to go through that would be, all right, well, what is your offer even going to look like? Because if your offer is not even close, I'm not even going to bother with a Form 220. Like, we're not even going to get to the 220 stage. But if the buyer agent reaches out, says, maybe they just send me a text message. It doesn't have to be anything formal. They can just be, all right, here's the outline terms of our offer. And depending on that, what could we work out with cooperative compensation? And then bring that to the seller, and I'm like, all right, cool. So based on that, we'd be willing to potentially offer this amount. Then if everybody gets on the same page, then send 220 and execute it, because there's no harm in signing Form 220 first. There's just not, because nothing in Form 220 becomes earned until the purchase contract is signed. Form 220 can just sit out there fully executed, but never become earned or due or payable or anything until the purchase contract is signed. So the seller always has a backstop there. If they hate the actual offer when it comes over, whatever. That said, there are plenty of agents that they want to see it all at the same time, and that's fine. That's actually addressed in the guidelines to Form 220. If you send it all at the same time, then, and now with the new rules, whether it's attached or not seems sort of irrelevant. I still wouldn't do 220 as an amendment, as an addendum to the contract, at least not yet. It's not designed that way, because the rules didn't allow it that way. So that's why it's not really formatted for that. But in any event, um, I think it's something where if you're going to send it all at once, just from the buy side, send it unsigned because you don't want a situation where cooperative compensation is not agreed to first. The seller just sends a contract back, says we're under contract, but cooperative compensation has not been addressed. Those hotline calls have been rare, but they have come up where people go under contract. They have not firmed up cooperative compensation first. Now the buyer and seller are under contract. And, the buyer may be looking at a buyer agent bill that they may or may not be able to afford. And cooperative compensation hasn't been, agreed to like they thought it would be. So I don't know. It's just one of those things where yes, in a world that you can follow the most logical steps, that would be it. But that said, I am fully sympathetic to you guys and the way you operate, under pressure, time crunch, doing things, non-responsiveness of the other agents. There's all these factors that go into that question. So to me, understand that I'm just giving a sort of a perfect world answer, but there's more than one way to do it. Just make sure you're doing it in a way that you're looking out for your client.
Somebody said that they heard rumor that even if state law changes, the North Carolina Bar Association would not permit compensation to be included on 2T. Is that true?
I've heard. And the only thing I know is that the law has been passed and the Real Estate Commission has already proposed rules. So I don't know what the bar would, the Bar Association or the bar would say about any of that. And they've not reached out to me yet, so I can't comment on it.
Going back to seller's offer of cooperative compensation, if a listing agent is asked by a buyer's agent if the seller is offering cooperative compensation, would an appropriate answer from the listing agent be, it depends on your offer?
Yeah. I mean, cooperative compensation, the seller just has no obligation to offer it at all. So if they want to make it, the amount conditioned on what the offer looks like, that's fine.
Someone said, how can I predict what amount to put on the buyer agency agreement if I don't know yet what the seller will be offering?
Yeah, I would say the way that question is structured is backwards. You need to be valuing your services and then work and, go try to earn the fee that you've agreed to with your buyer. And your compensation should not be dependent on what the seller's offering.
Someone said, could you use Form 710 to amend to include a builder seller bonus that was not originally in Form 201, if part of the bonus is being rebated back to the buyer as justification for accepting additional compensation?
Yeah, like I said, amendments to a buyer agency agreement to increase compensation, could they, they may be permissible if they comply with the settlement. So what I would say is talk to your BIC about it. And, certainly, I think there's scenarios where if there is a significant benefit to the buyer client to amend it, even if it means more compensation or different scope of services or things like that. I think there's scenarios where that could work. I can't say specifically in that scenario whether it would work or not, but, talk to the broker in charge and, see what they think about it.
Someone said, if the seller has already agreed in the listing agreement to pay a certain amount of cooperative compensation, how could it be negotiable later if they already agreed to that?
Well, the way it's phrased in the listing agreement is that, the amount of cooperative compensation is authorized. And, that's an up to phrase, not just because you're authorized to do something doesn't mean that you have to do something. I've got a credit limit on my credit card, but that doesn't mean I have to go out and spend that money. Same thing with cooperative compensation. That's the way the form has always been structured, not just the most recent version.
And to go along with that, someone said, how come our form does not have the wording up to like the South Carolina listing agreement has?
I'm open to it. I listen, I don't I am just a monkey. I do what I'm told. I don't get to, listen, that is up to forms committee on what they want to do with that particular language. But I will just say that discussion has been had. I do not remember the exact context of it, but it is not in there.
Yeah.
But it's definitely implied. I mean, no doubt. The language, I think, still insinuates up to, authorization, may, those things are not, mandatory words.
Yeah, I think the discussions at Forms Committee has been that, a lot of what we do is seeing what is happening in the marketplace. And then unfortunately, we have to be reactionary to that. So we're always just a little bit behind, what we're seeing going on in the market. So the changes that we have made were in response to the settlement, but we're going to continue to see how the market shakes out. And then the committee could look at things again. Let
I think it's important that everybody understand that this is a completely fluid situation. We're going to be reviewing and constantly, and there's probably more changes to come. In on a bigger picture, nationally. So who knows? But it's just going to remain fluid. That's correct.
Someone said, essentially, should they always start their buyer agency agreement high, and then if the seller offers less, edit it? So to that, I will say that you negotiate your compensation with your buyer. Whatever the buyer feels your services are worth, that is the amount that goes in the buyer agency agreement. If you later decide to accept less, you can always accept less. It's the more that gets problematic. Good with that answer, John?
I couldn't have said it better.
Oh, come on. Someone says, I have an attorney that has approved language to be included on an email, which has both the offer and Form 220 attached. The language indicates that both forms must be signed. One is not effective without the other. Is that a sound document and verbiage? Basically, how do you feel about that?
No, I mean, yeah, I mean, 4220G recommends that you work with a lawyer to do that kind of an email. But even if you do, I would still recommend sending any purchase offer unsigned unless you got 220 signed first. It's just that way is fail safe. You cannot accidentally go under, a contract for the sale of the property if the buyer is not, or if the buyer hasn't signed the offer first. So it's one of those things where, you got to do what's best for your client. And yeah, no, there's definitely there's factors that go along with that. On the one hand, you want to do what's best for your client, but on the other hand, you don't want your buyer's offer to be, in competition with a bunch of other offers necessarily, and yours is the only one that's not signed. It's one of those things where, if there is a lot of competition for a property, then you're going to need to look what is in the best interest of the buyer, what risks are we willing to take, and certainly if you got language like that in there, I would argue that if it's done right, then it definitely could be effective. I don't see it as any different than other scenarios where agents are able to put conditions on the delivery of certain documents. And that definitely happens. I don't want to go into those, but it happens in other contexts too, especially with due diligence repair requests and things like that. So
Someone asked if, let's see. I think they're asking if the seller is offering more cooperative compensation than what is in the buyer agency agreement, is the firm responsible to refund the seller the difference? And the answer to that is no, there would not be a refund because it wouldn't be paid. So
Right.
instead of offering what the seller is accepting, Form 220, the offer from the seller, would simply match the buyer agency agreement and no more. So you cannot collect from a seller more than what is agreed to in your agency agreement.
yeah, I think that's a good answer. And it also sort of underscores the importance of keeping firms' fees separate from cooperative compensation in the listing agreement.
Yeah. Ooh, getting off of compensation. Someone says, how do they operate if the buyer wants to pay the escrow money at the end of the due diligence period? So if you put earnest money in initial earnest money, it is due within 5 business days. If you would like to make it due at a later time, which, why not at the end of the due diligence period? I've certainly done it. You would use additional earnest money instead, and that allows you to put in a due date. Keep in mind that due date is time is of the essence. And if I'm not mistaken, that means that that has to be paid via certified check. You then lose the option of doing personal check, whatever. And the money has to be paid on the date that is named on an additional earnest money line. Let's see. My BIC told me under section 7 of the listing agreement to check my seller doesn't agree to offer compensation, and then told me to have them fill out 220 stating what they would offer. Earlier, it sounded like you guys don't recommend that.
Mm,
That's John's thinking face.
Yeah, if the seller's signing it, and everyone's kind of clear on what the intent is, then, is that the best way to do it? Maybe not. I'm just trying to think if that could potentially lead to some unclear terms between the listing firm and the seller. I don't know.
I like where your head's at, John, because we don't turn this into a training class, but I think it's a best practice. I'd want it on the listing agreement,
Yeah,
and you'd have better guidance on what, as a listing agent, what your boundaries are, what your parameters are.
I agree.
We've only got just a couple of seconds left here until we are signing off. Let's see. What about agents who report they will refuse to show their clients a property if co-op compensation does not match what is in their buyer agency agreement?
Yeah, I think that's a big problem. And there's a Q&A on this, and I think there's pretty serious antitrust concerns by holding your client's offer or even like showing them property. There's license law issues, there's antitrust issues. It is, to me, definitely not something that I think is not good. No, I don't think that's, but I keep hearing, I keep getting calls about it, so it is a concern of mine. There's a Q&A on this too already. So you can check that out in the Q&A library. So I won't go into detail on it, but no, holding your client's offer hostage or holding your client hostage, I don't see how that's good for the consumer. I don't see how it's good for the seller, the buyer, the agents, anybody.
Thanks,
That's
John.
correct.
All right. Thank you all for being here today. I hope you came away with some helpful information and links as you can continue to educate yourself about these changes. Following this program are two ways to take the survey. Scan the QR code now or wait for the survey to pop up following the conclusion of this program. The presentation and this recording will be available on the Canopy Realtors website. Have a wonderful day. Hope to see you all soon. Thank you.